Lordship, this appellant has filed an application for temporary release on bail, sir, on account of the pregnancy of his wife, who is expected to deliver the child from 19 December to. He is the appellant convicted for life sentence. Sir, because he is in jail from 13 January 2000. He will arrange for money and all the requirement for the new Hamid submission for limited period. Jail sentence may be suspended. I am on bail during course of trial, and from 13 January 2022, I am undergoing the jail sentence as convict, sir. Yes, sir. Sir, in parole, he must have come, sir. And definitely, sir. And there's nobody in his family, sir. For limited purpose, his jail sentence may be suspended, sir. There's to take care of the wife and the. Uh, Definitely, he is suffering, and the wife and child should not suffer, sir. Definitely, sir. The persons will reform, sir. Our system is limited period. Submission. There's nobody in the family. Two years will come completed, sir. In January 2024, sir. So my humble submission for the sake of, because any limited period, sir, 1 month, 2 months, any, my lord, may. No. Oh, that is the natural human being, sir. For welfare of the wife and the child in womb, sir. As there's nobody, sir. I've mentioned in my application. They not to single murder, sir. He is not the head of the assault, sir. Being the relative of the main assailant, he has been arraigned as an accused. Number of persons have been arraigned as an accused, though there were limited persons, though the offense has been committed. But Mohammed submission, sir, this is an application because he has not applied for on merits. It is an application for temporary release on bail for the welfare of the wife and the child in womb, sir. Application on the humanitarian ground, this has been filed, sir. Definitely. They have realized, sir, that life sentence. Yes, sir. Yes. Yes, sir. Yes, sir. Yes, yes, definitely. Everything has to be taken care of, but this is definitely, sir. Yes. Yeah. Had there been any persons, I would, yes. My humble submission, sir, the incident has taken place first at the house of the accused persons who have committed the offense. He being the relative has been later on. No, no, no. I have not come for marriage, sir. So my humble submission, the wife and the child. Not in every cases we are coming, sir. When there are other persons in the family to take care, they don't even come, sir. Yes, yes, yes. Sir, even has definitely, sir. But the problem is with the wife and the child. On that aspect, my lord may consider my bail application. Definitely, I bow down before my lord, sir. He will take care in next time, sir. My humble submission. Yes. For a short period, he may wish to take care for 15 days, 1 month, sir. So that the delivery, it is the first delivery, sir. Thirteenth January 2022. 2022. Oblige.
We are adopting the action we have filed in the case.
So out of 6 accused, Lordship have considered the bail application of the 5 accused persons, my lords. These are the orders, my lords.
7.1.
47. These are the orders of the accused persons.
My submission is my, but I've gone through the orders. Just I just point out 2, 3 points. Permit. Time permission I would like. For one, my lord, this accused Raman having the allegation and that he has been seen while using the lathi to assault the deceased. So his case is not like that, that none has seen him while beating him. Vishnu Dutt's case is that he is not there in the FIR, but his name is there in the FIR. Now, in respect of injury parts, my lord, but this person is having the overtext. One more. Secondly, my lord granted the bail to others on reason being that 3 injuries were found and there were as many as 6 persons those who have assaulted. So my lord, in proportion, 3 injuries are not corroborating. But my respectful submission, the one thing which I would like to point out is the MLC, my lord, where the doctor has done the MLC of a deceased prior to his death before referring to the higher hospital. He found as many as 9 to 10 injuries, my lord. That may be seen, my lord, that MLC is annexure. This is, I just point out from the witness, my lord, the PW3, my lord, and PW4. I'm just reading the relevant portion of it.
So he is Raman.
Raman alias Kakkuz. रमन शुक्ला में बंदूक की बटों से मारने वाले बाबादीन, शंकर, ब्रजेंद्र, रामबाबू और राजकिशोर थे तथा राजेंद्र शुक्ला व रमन शुक्ला डंडे से मार रहे थे। मैं चिल्लाए, इतने में राममूर्ति, गौतम और सुरेश तिवारी आ गए। हम लोग चिल्लाए तो सभी लोग अंदर से माँ बहन की गालियां देते हुए भाग गए। फिर हम चारों लोग कमरे के अंदर गए तो देखा रेणु सिर में चोट थी एंड सो एंड सो।
So parrot will lordship see PW3. बाबादीन शुक्ला एक 315 बोर की राइफल, देवेंद्र शंकर 12 बोर की 2 नली, ब्रजेंद्र 1 नली, राबू 3। No, no.
I'm just reading it's a PW4, my lord.
Yes, okay.
PW4.
So I'll come to PW4. No,
this is Paramatma Deen Tiwari.
Yes.
I'm reading 1, 2, 3, 4, 5, 6, 7, 8, 9. 14th line, my lord.
14th line of
PW4, my lord.
paragraph.
Paragraph first, my lord.
Paragraph. Sir, if lordship kind of see 1, 2, 3, 4, 5, 6, 11th line. Follows. Sir, if lordship kind of see line number 11 from the top. मैं दौड़कर घटनास्थल पर पहुंचा तो मैंने देखा समाज भवन कमरे के अंदर 5 लोग बंदूक की बटों से मार रहे थे और 2 लोग डंडों से रेणु उर्फ लक्ष्मी नारायण तिवारी को मार रहे थे। बंदूक की बटों से मारने वाले लोग बाबादीन, शंकर, ब्रजेंद्र, रामबाबू और राजकिशोर थे तथा राजेंद्र शुक्ला व रमन शुक्ला डंडे से मार रहे थे। मैं चिल्लाया तो इतने में समझ all were assaulted by means of butts of guns of 4 persons and 2 were by lathis. There are 2 injuries, one on the head, back, and the leg. So, according to the eyewitness, if lordship may PW5 also. But there's no specific allegation. PW5 may also be seen.
Yes. Regarding this, have gone through that. But fine. My submission is that the deponents I have read my lord that PW4. This is what my submission in respect of assaulting and who has seen that. Now One more thing which my lords have pointed, that my lords have taken care of that Dr. PW11, who said that he has executed the postmortem of that. But my lord, PW10 is also there. My possible that it may take consideration in respect of that. PW10 is the doctor who has done the MLC of this person, and as many as 10 injuries were found, my lord. These three were the but this is very much there. This is there that the assault has been done. I have read those two lines. This is very much there that is there. That is there. This what I have to inform my lords. That is not there. I have gone through the evidences of minus 149 as well as up the right.
Medley.
Lord, by way of this petition, petitioners
9 inches and PW10 is just 10 inches. That is there. That is for my lord's consideration. Which was
I was
9 and 10. That is there. Clearly speaking.
I was telling him that you almost got it. I was telling him that you almost got through. Great.
petitioners are challenging the impugned order dated 13/12/2022, my lord. P1, my lord, where by amendment, my lord, the biochemistry subject is excluded from the list of allied subjects of botany and zoology, my lord.
Because 1 and 4 are perhaps of Indore, my lord.
My
The
lord,
petitioners-
Indore and 2 are from
1 and 4.
Lord. We are challenging the impugned order dated 13/12/2022, my lord, whereby the way of amendment, my lord, biochemistry subject is excluded from the list of allied subjects of botany and zoology, my lord. My lord, earlier,
Reply, but as far as the interim goes, my lord, this order is of 22. The Public Service Commission issued the advertisement in March of 23. The exams have perhaps been held also on October of 23.
no, my lord, the last date of filing the form is 15th December.
I was instructed it happened.
Last date is 15th December, sir. नहीं सर, ये काइंडली अप्रिशिएट, मतलब पेज नंबर अभी इन्होंने एक्सटेंड कर दिया सर, पेज नंबर 173
Included in para 5.11 also.
73, my lord, 173 172 172 sir. Let me please apply.
Yes, my lord, he's attached at 170. There's an interim, he's attached that order, my lord.
What time for us?
143, my lord.
143. Same subject, same severity, sir. But may I say that other cases may be linked with some other cases. On same subject, same everything is similar. Well,
Well,
In one case, some other counsel is one in one.
You can share the field.
Lordship, kindly list this matter की Lordship. इसमें कुछ default आ गए हैं वो yes Lordship. Lordship ये civil judge के examination के लिए है. Lordship senior counsel इंदौर bench में गए हैं. Lordship senior counsel out of station है. Yes, Lordship.
Say appeals, if one could be taken. 178 of 23. Last date notices were issued on delay. Your Lordship, the delay is about 1745 days. Issue was in respect of whether the timekeepers who are working in the work charge establishment in the same pay scale as admissible to Amins who are working in the regular establishment. The nature of their job, the nature of their work, their selection, it is entirely different. They belong to separate establishments. And Your Lordship, the writ petition, in fact, Your Lordship, was decided on the ground that in terms of orders passed in two cases, that is A.L. Thakur and R.K. Lakhera. Thakur, Your Lordship, the earlier, the issue had already been settled in the year 2001 and 2006 in the case of Kiran Rangnekar and Munna Lal Bansal. Now, both these judgments were not taken into account while passing the order in A.L. Thakur. Therefore, we say that because those earlier judgments were not considered.
My submission is the client has taken away the because affecting in the response. The client has taken away the file, my name as affecting in the response. Yes, ma'am. He has not approached us, ma'am, yet.
Well, we have to scale. But the order, Your Lordship, we have to scale in terms of the orders passed in AL and
In fact, that is allowed till the Supreme Court, ma'am. Not. Mal. Client has not approached us, my lord, yet. Mal. 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 We called him, but he never approached us, mal. Mal.
My lords. That's in this appeal, my lords, I'm challenging the impugned order passed by the Honorable Single Judgment, whereby my rejection order on the ground of compassionate appointment has been affirmed. On the sole ground that as per clause 4.1 of the policy, if there is a family member of the We have, my lords have already passed.
Passed an order, you have item an order passed by your lordship and earlier, recently your order to hold. It was, an order was passed to follow Prajesh Srivastava, which clearly stated that there was death. I'm aware that such an order has been. Purpose of compassion point. Submission is established that the death took place 7 years prior, 8 years ago. And the immediate financial crisis, the purpose of compassionate appointment, which is not a normal mode of recruitment, that your lordship was passed by the honorable, that
That
financial crisis is, they tide over that immediate financial crisis, and then after 7 years they come to.
lords, in this case, my lord, the death took place in the year 2020 itself. My lords. The ejection order was passed in the year 2020. No delay as far as the
Court is also another issue if I.
'22. Lords, it was brought, my lords, but the Red Court has relied on the judgment of Prajesh Srivastava, my lord. But the judgment of Prajesh Srivastava dealt more specifically on the question of term, the meaning of the term family, my lords. It did not adjudicate the issue of financial status. No, my lord, this financial issue has not been touched by any court. Only my lords have given that finding.
Lords, I've come against the proceeding of lapse which has been initiated against me, my lords, against my minds. Lapse proceedings have been initiated against my minds, my lords. My lord, this matter is already sub judice before this honorable court in writ petition number 2885 of 2012, my lords.
My submission is that 20, my lord, of the atomic and hydrocarbon energy minerals concession rules 2016 is a complete code in itself, and the contingency which the petitioner is talking may well be taken care of. These are premature proceedings. Sub rule 3 says where a lessee is
Yes.
no. There the issue is different, my lord. Here he says that there are certain reasons as to why he is not able to commence the operation, and those reasons will well be taken care of by the state government under sub rule 3 of rule 20. I will just read sub rule 3. It says where a lessee is unable to commence the mining operation within a period of 2 years from the date of execution of the mining deal or discontinuation of mining operations for reasons beyond his control, he may submit an application to the state government explaining the reasons for the same at least 3 months before the expiry of such period of 2 years. So, my lord, he says there are genuine reasons as to why he could not commence. The rules provide for the procedure to deal in such cases. Now, here we have only issued a show cause notice, which is under challenge at page number P6. He may, under rule 20, sub rule 3, give the reasons and that there are no malafide alleged, because that may be considered by the competent authority, which is the state government. My lords have dismissed not similar, but where.
My lords, may kindly see page 39, my lords. First. My lord, this notice has been issued to me, my lords, for declaring lapse of my mines. Now, my lords, this notice has been issued for non-operation. Now, my lords, what had happened, the petition which I'm talking about, 2885 or 2012, my lords, the forest department, if after operating for a period of 20 years, my lords, the initial lease was granted in my favor from 78 to 98. My lords, my reply is already there. I have told the authorities that this writ petition is pending and it is because of the forest department that they have not granted me. No, my lords may see my reply, my lords. My lords may see page number 39, the application which the state is talking about, my lords. I have already filed that application at page 39. My lords, the reason is that I could not operate the mines, my lords, because the forest department is not issuing NOC in my favor, my lords, to operate the mines. My lords may be tagged along with. My lords may be tagged, my lords. No, my lords. My lords, it may be tagged with the main petition, my lords. No, my lords, it's not. My lords, what is happening? They are proceeding against labs.
File reply, Lord, the state is contesting in dispute. But this is his contention, Lord, the documents do not say, my lord. Lord, 2003 order, my lord, the SE adjudicated, he passed an order, he challenged that before the tribunal. All, I'll file.
My lords. Third week commencing after vacation.
Page number 13, Lords. Applicant is required to file the appeal before the appellate authority within 3 months from the date of communication of the disputed order. Further, the appellate authority may be condoned with delay up to 1 month in sufficient cause of the such, along with condonation of delay before the 10/8/2023. I therefore hold up in the interest of appeal is time barred, Lordship. Lordship, हमारा सिर्फ 46 days का डिले है. लॉर्डशिप हम वाइफ का ट्रीटमेंट चल रहा था लॉर्डशिप, उसमें थ्री मंथ्स लॉर्डशिप. लॉर्डशिप जजमेंट भी है इसमें थोड़ा. Lordship, para 3, Lordship. Normally, period of limitation of filing the appeal would have further the grace period of 30 days, Lordship. Lordship, why पर भी लगा ट्रीटमेंट का लगाया हुआ है Lordship. Annexure P4, Lordship.
The petitioners are challenging the rules regarding the eligibility for the post of civil judge. Your Lordship, the identical case 15150 up to 2023, the Honorable Court issued notices, Your Lordship, but the interim relief has not been granted. Your Lordship, today the identical case is listed before the Honorable Apex Court, Your Lordship. And the SLP has also been filed for seeking the interim relief, Your Lordship. So it may be taken tomorrow, Your Lordship, awaiting the taking the information from. That in this case, I am challenging the advertisement on the ground that the reservation for the EWS category has not been provided for the post of civil judge. Millard, after the 103rd constitutional amendment, Your Lordship, the reservation for EWS category candidate has been provided. Your Lordship, the advertisement issued on the basis of Your Lordship.
Yes, it is not being given, ma'am. EWS is not being given.
Millard. That the rules have been amended, Your Lordship. This that it may be stated, Your Lordship, this is against the constitutional mandate, Millard. Some returnable date, my dear.
Matter.
So this is for the protection of the Dumna Nature Reserve and the catchment area of the Khandari Lake.
For next week, Honorable is to support in this matter.
But interim orders are there. They were. I'm sorry.
There is a vacating stay by the respondent.
So what has happened? This house is situated in a dense market area in district Narsinghpur, Lordship. The gold market, Lordship. An order has been passed in favor. Municipality was directed to demolish the building, Lordship. And appellant was misleading the court, Lordship, throughout. What has happened? When in 2013, they have accepted, I have filed the initial in the Lordship. No, and it's in my favor, Lordship. I am for the respondent number 1. I am the landlord, Lordship, and they are tenant, Lordship.
Yes, well, that was under challenge. Before the what happened? If Malad may permit, it will be heard. Finally, Malad, I addressed. An order of eviction and demolition was challenged, Malad.
They have not challenged the order
eviction of eviction.
Corporation. They have challenged the order.
SGO has passed the order of eviction. So we filed a civil revision at Rent Control Authority. There is no such order which has been. By reply, they have filed the communications, my lord, which under 221. Well, my case is that initially eviction order was passed by the SGM, my lord. We filed a civil revision, my lord, challenging that the Rent Control Authority has not given an opportunity of hearing to us. No issues were framed. Now, stay was granted, my lord, and civil revision was heard finally, my lord. At the time of final hearing, they said that it is not an order under eviction. That's why, my lord, the civil revision is not maintainable, and liberty was granted to file a writ petition because there is no provision of eviction which has been mentioned. So, I preferred a writ petition. Now, in writ petition, my lord, the state government was directed to file a reply under which provision this order has been passed. So, they come with an affidavit, and under section 133, we have passed this order of eviction. Considering that 133, my lord, entire provisions, judgment has been considered, the honorable single bench was of view, this is a wrong order. 10,000 cost has been imposed in the SDM. You have passed you have glove in hand with the landlord, and this order was. But after passing and quashment of that order, my lord, an order has been passed that may be considered, my lord. It's a principle of equity that order is passed, my lord. My lord, page 15. However, setting aside the improving order 1911-19 passed by SDO, Narsinghpur revenue case will not grant any direct or substantial relief to the petitioner who have already obtained an order of allotment of another house which is available on record on the pretext of rented accommodation being in a dilapidated condition. Therefore, they are liable to vacate the property in question to be handed over to the landlord for demolition of the said property within a period of 30 days from the receipt of certified copy. It is made clear no repairs will be permissible in the suit property. The property will be demolished within a aforesaid period and further action will be taken in accordance with law. The demolition report will be furnished to the CMO within a period of 15 days. A cost of rupees 10,000 is imposed upon the SDO Narsinghpur for acting as an agent middleman to be paid to the District Legal Service Authority to be utilized for the welfare of plural litigants. He will pay the amount cost out of his pocket within 15 days and shall furnish a receipt before registry of this honorable court for pursual. Now, we challenge this part of the order, my lord, once the order has been set aside. And we give an undertaking that we are not in a position to continue with that allotted house. We cannot pay that amount of 95,000, and that's why even we can only stand in this house only. And we are even submitted that we are surrendering that house, my lord, in the writ appeal, my lord. This is the issue, my lord. So once the order, my lord, we have mentioned in the affidavit, my lord, surrender, my lord, the process is that it has been allotted. Now we cannot pay that, they are automatic, they can cancel. We are not in the position of that house. So we have given undertaking, my lord, even you take, we cannot pay that amount 95,000 for. No, my lord, it's a very down total. We say that as per law, you have to proceed. If you want a eviction, you proceed in accordance with law. How could 133 CRPC provision has been exercised? And once that has been observed, it is an illegal proceeding which has been taken. So we have. Ma'am, it's a poor person. On the basis of that house, I have to vacate, my lord. He can proceed in the accommodation for tenancy.
We have given an affidavit before the court. This is proper. We have rectified the entire. This is already on record. Photographs are already on record. We have constructed the entire property properly. This is not in a deplicated position. That's the only submissions. And if my lords are dismissing now, they have at the time of Diwali, the court has given a 30 days time. Now we have to arrange or we have to search. Sometime at least the court has to be.
But so they are undertaking maybe recorded because we
If-
use single. Hello.
15 vacating. We have no other alternative. Some more time. We give an undertaking. Yes. My lord, we will file affidavit. My lord, may I observe this? My lord, we will give affidavit within. No, my lord, we will give. He is in Narsipur. Within 2 days. By tomorrow. I am grateful. Yes, yes, yes. I am grateful.
I'm praying for a Passover, my lords.
He's the student, my lords. He got selected in games, my lords. And
Should be a lot. Those is provided to us, the college could not verify because it is available to be seen only through this login. But I checked on the website, it was there. Although the orders have been passed in respect of returning back the documents after the completion of the
page number,
file.
my lords, page number 73. 3, my lord. Only one petitioner.
Stand number 2.
P10, my lord, is the order. And I've been, my lord, impugn order has been passed P10, my lord, at page 85. I've been asked, my lord, to be evicted, my lord. My lord, because of the order at page 40, my lord, the arbitrator, my lord, who's been appointed, my lord, 40, my lord. Mr. Akash Chaudhary, my lord, he was appointed as an arbitrator. There was, my lord, this case, my lord, P10 at page 85 is the order which has been passed under the Act 1974, which is, my lord, MP Lok Parisar Bedakli Adhiniyam. This is, my lord, for illegal occupants, my lord, who are removed, my lord, under this special act. Now, I am the person, my lord, who was put, my lord, in possession of this property by virtue of an agreement. That agreement, your lordship would find, is at page 21. My lord, this is by, my lord, the tourism department. Now, my lord, there is a clause, my lord, for extension, my lord, of the lease period that your lordship would find is at page 25, clause 2. I sought for an extension after the initial period was over. And there is, my lord, consecutive 2 periods, my lord, I can seek extension if the previous period has been, my lord, successfully completed. That clause, if your lordship would see, is page 25. My lord, this is, my lord, an educational, my lord, coaching classes, my lord, which are going on here. CLAT coaching classes, my lord. My lord, law students, my lord. And my lord, that's CLAT, common law admission test, my lord. Now, my lord, under this particular, my lord, agreement, if your lordship may just turn to page 29, there is an arbitration clause. And the arbitration has been invoked, my lord. And the arbitrator has been appointed, my lord, by the tourism department itself. My lord, for extension, my lord, we had sought extension in terms of the arbitration. Period expired, my lord, on 28th of February 23. And I sought an extension, my lord, on 24th of 31st of January 23. That is, my lord, one. No, my lord, it was refused. So we invoked the arbitration clause saying that it could not have been in terms of the clause because it says that there is, Lord, it was refused by them, Lord. Refusal, my lord, is at page 35. The date is 31st of January 23. And immediately on 7th, dispute before the arbitrator. Yes, my lord. Now the arbitrator was appointed at page 40. We referred, my lord, and we wrote to the arbitrator as well. Our section 17 is pending with the arbitrator. In between, my lord, the subdivision officer, my lord, issues notices to us that I am an illegal occupant and I have to vacate the premises immediately. Now, my submission is, my lord, once there is an arbitration clause and the matter is seen, Lord, I have challenged this order at page 85. I was issued, Lord, by the subdivision officer for vacating the premises during arbitration.
My lord, it has been noted that it expired and it has not been renewed. To find that since the lease was not renewed, therefore it is an illegal possession. It has been appointed by the tourism. Application was referred to that 17 applications. 1 and 2. Saranani is referred. Says that since it was this period was not has not been renewed, therefore it is.
Subdivision officer P10, my lord. Pending. Obliged. Deeply pledged.
File the modification on behalf of respondent number 2. To file the reply document. Seven month amount है prayer my lord restored the possession my lord. Already removed, which was already removed my lord. On the ground my lord, the amount shown in the prayer my lord, which was due. Hence the all my lord, as per interim order directed to continue the possession of the my lord in the premises. It was already removed my lord. My lord, directed as interim order, my lord, to permit to continue possession of the disputed stock, my lord. It was already removed, was already revoked by the, so we have filed the modification. On the ground, my lord, the amount is due. But that premises is already vacated, my lord, as per the. Sir. Sir. तो ये था जो एंट्री ऑर्डर में जो डायरेक्शन इनको फिर से have not traced this.
My lords, Shri Ajay Gupta is connecting through VC in the matter. My lord, the petition is dismissed or the IA? IA. Obliged.
Rejoinder is ready, Lordship, to file. Rejoinder, Lordship has since in previous hearing that whether you have the Udyam registration or not. Well, if you have, then file it. Rejoinder, 1 week time.
The contract rate agreement is already tenure is expired. It is rendered ineffectual.
The intra-court appeal, Lordship. What has happened? Earlier, the notice has been issued. Respondent has, state has filed the reply, Lordship. What has happened in this case, Lordship? The annexure A1 is the impugn order. What has happened in this case, Lordship? We filed a writ petition before on single bench, Lordship, whereby, Lordship, we made a request. We made a prayer that the FIR should be quashed because the FIR under section 4A of the Gambling Act, Lordship, is a non-cognizant offence. Therefore, if the non-cognizant offence committed by the accused person ultimately there is a provision under section 155(2) of the CRPC. The Honorable Court, that is page number 13, Lordship. Counsel for petitioner, in fact, has failed to sustain as the why the FIR non-cognizant offence cannot be registered, and what is the provision under which any such embargo is provided. Section 154 of the CRPC provide if the information related to commission of cognizant offence, if given orally to an officer in charge of police station, the same shall be reduced in writing, and then investigation will be started. Likewise, section 155 of the CRPC very categorically provide that if the information is given to an officer in charge of police station of commission or within the limits of the such station of a non-cognizant offence, he shall enter the cost to be entered the substance of the information in a book to be kept by such officer, but investigation shall not be made without permission of the magistrate. From the provision of section 155 of the CRPC, it is clear that even in occasion of non-cognizant offence, FIR can be registered and investigation can be done. If that is done, as the section 173 of the CRPC, after completion of investigation report of the said investigation can be submitted before the competent court, which can try the alleged offence. I do not find any provision which say that the offence is non-cognizant charge sheet. That charge sheet cannot be filed. Section 4A of the Public Gambling Act provide that this the punishment that too with fine or imprisonment. In my opinion, the submission made by the counsel for the petitioner is completely misconceived, and FIR and the charge sheet cannot be cashed on the ground that charge sheet under section 173 of the CRPC cannot be filed in a non-cognizant offence. Kindly see, Lordship, the section 155(2). 155. Information as a non-cognizant cases and investigation of such cases. Number 1, when information is given to an officer in charge of police station of the commission or within the limit of such station of a non-cognizant offence, he shall enter a cost to be entered in the substance information in the book to be kept by such officer in such form as a state government may prescribe in this behalf, and refer the information to the magistrate. Second, no police officer shall investigate a non-cognizant offence without the order of the magistrate having power to try such case or commit the case for the trial. Now, here's my case that after 154, FIR has been registered, Lordship. Then they have filed a charge sheet under section 173 before the London Judicial Magistrate First Class at Jabalpur. Now, contention is that, Lordship, the offence is, since the Bhajan Lal case is very much clear that in this aspect, Lordship, I have quoted in my writ appeal also, para 6, Lordship. There is no evidence available in records. State of Haryana versus Chaudhary Bhajan Lal and other AIR 1992, Supreme Court 604 108. In the backdrop of interpretation of the various relevant provisions of the code under chapter 14 and of the principle of the law enshrined by this court in the series of decisions relating the exercise of extraordinary power under section under article 226 of or inherent power 482 of the code, which we have extracted and reproduced above, we give the following category of the case by illustration. Yes, my point is that, Lordship, under section 154, it is very much clear, Lordship, the FIR is only registered on the cognizant offence. Now, here is the case, Lordship, if the offence is non-cognizant, ultimately, they have to file a report before the magistrate. In my case, no magistrate report has been. Yes.
File the reply. I would like to take my attention that the offence has been committed on by the petitioners of the Gambling Act, Section 4. Section 4, there are 9 persons. The team has been considered. The entry has been made. Example. Now, this cognizability will depend upon the gravity of the offence, because Section 2C of the CRPC may kindly receive. He has been charged for the with section 4A of the Public Gambling Act 19. Now that is what I'm trying to point out, my lord, that will depend upon the gravity of the offence, my lord, regarding, and that is and section 5 may kindly be seen for a moment of this act, my lord, which says, my lord, that the powers to enter and authorize the police to enter and search the premises. May I read with your permission? May I read this, my lord? Depend upon, my lord. Punishment, my lord. Whosoever found in any house, vault, enclosure, room, or place playing or games with the cards, dice, counters, money, or other instrument of gaming, or is found there present for the purpose of gaming, whether playing for any money, wager, stake, or otherwise, shall be liable to be fined not or to the imprisonment of either description as defined in IPC for any term not exceeding 1 month, and any person found in common gaming house during the gaming or playing herein shall be presumed until the contrary proved to have been there for the purpose of gaming. Yes, sir. But the next section, section 5 of this act may kindly be.
No.
No, this is 4 and 4A. 5, my lord, 5 is the powers of the police to enter and authorize the officer to search the premises.
Yes, sir.
Non-cognizable as
Yes, sir. Yes. Punishment for printing, publishing digit, figure, sign, symbolic, or picture related to belief. Whoever prints or publish in any manner whatsoever any digit of figure or sign or symbol or picture or combination of any two or more of such digit or figure, sign and symbol, picture relating to Varli Matka or any other form of gaming under any heading whatsoever, or by adopting any person from the device or 4A. Sir, there is allegation against the on IPL सट्टा का आरोप था. Yes, sir.
yes, my lord. My lord, kindly see, my lord, we have also mentioned our reply also that this section, my lord.
Now, here, if the submission of the state would be accepted, Lordship. Now, section, kindly see the section 5. Power to enter. If the magistrate of district or other officer invested with the full power of magistrate or district superintendent of police, upon credible information and after such inquiry as he may think necessary, has reason to believe at any house, vault, and so, it is viewed as a common gaming house. He may either himself enter or by warrant authorize any officer of police not below such rank of state government shall appoint in this behalf to enter, which such assistant as may be found necessary by night or by day, and by force if necessary any such house, vault, enclosure, rooms or place, and may either himself take into custody or authorize such officer to take him into custody all person whom he or such officer find therein whether or not them actually gaming, and may seize or authorize such officer to seize all instruments of gaming and all money and securities for money and articles of value reasonably suspected to have been used or intended to be used for purpose of gaming, which and may search authorize officer to search all parts of the house. Now here is the contention is that, Lordship, kindly see FIR itself is very much clear, Lordship. The sub-inspector has lodged the FIR and he is the complainant, he is the informant in respect of that commission of offense, Lordship. If they said that the deputy superintendent of police would be appointed in those cases, Lordship, ultimately they failed to do so. Yes, sir. Yeah. Yes, sir. No, there is no order. Yes.
One 154 of RPC.
Sir, trial could. Let the trial. Yes.
Five record. This report is available. Report is here.
I would have called the file. My lord, sir. Two cases. In one case already there is only two cases. Two cases. एक केस में पहले से है, दो केस और.
Served to appear. Ji. My lords, on last date of hearing, my lords ordered that we should serve notice to them, and notices, Hamdas notices have been served. My lords, Yes, my lords. My lords, respondents issued a proposal, a request for proposal on 12th Jan 2017, whereby bids for a smart working system was opened. And thereafter, my lords, we as petitioners made a proposal, and our proposal was accepted by the respondents. And my lords, we we signed up for an agreement on 26th July 2017, which is marked as Annexure P2, my lords. Yes, my lords, and my lords, only 15 days are left as the time limit which is prescribed as per the 7th B of the Adhiniyam Acts, my lord.